Matter of freealliance.com. June 28, 2022. Our office has consistently stated that the mere fact that a re-evaluation of proposals after corrective action varies from the original evaluation does not constitute evidence that the re-evaluation was unreasonable, since it is implicit that a re-evaluation can result in different findings and conclusions. We have also generally found the argument that a re-evaluation following corrective action was per se unreasonable because it was not reconciled with an earlier evaluation to be without legal or factual basis. This is because there is generally no requirement that an agency reconcile a later evaluation with an earlier one or explain why the evaluation changed. Quite simply, the overriding concern in our review is not whether an agency's final evaluation is consistent with an earlier evaluation, but rather, whether it is reasonable and consistent with the solicitation's stated evaluation criteria. One notable exception to our decisions addressing this issue is where we deemed it incumbent upon an agency selection official, when confronted with adversely different evaluation results of essentially the same proposal, submitted by the same offeror, under the same solicitation, to seek some sort of explanation or otherwise arrive at an understanding of the basis for the different evaluation. We have also subsequently stated that our decision is limited to circumstances where the same SSA reviews starkly different evaluation conclusions of essentially the same proposal under the same solicitation, and the unique circumstance where the agency selection official was personally involved with reviewing proposals and affirmed specific conclusions about an offeror's proposal. In reviewing an agency's procurement actions, we do not limit our consideration to contemporaneously documented evidence, but instead consider all the information provided, including the parties' arguments, explanations, and any hearing testimony. While we accord greater weight to contemporaneous materials as opposed to judgments made in response to protest contentions, post-protest explanations that provide a detailed rationale for contemporaneous conclusions, and simply fill in previously unrecorded details, will generally be considered in our review of the rationality of selection decisions so long as those explanations are credible and consistent with the contemporaneous record. In reviewing a protest challenging an agency's evaluation of proposals, our office will not re-evaluate proposals nor substitute our judgment for that of the agency regarding a proposal's relative merits, as the evaluation of proposals is a matter within the agency's discretion. Rather, we will review the record to determine whether the agency's evaluation was reasonable and consistent with the stated evaluation criteria and applicable procurement statutes and regulations, and adequately documented. A protester's disagreement with the agency's evaluation judgments, without more, is insufficient to establish that an evaluation was improper or lacked a reasonable basis.